Welcome to Synergy's Subject Matter Expert Insight webinar series. This webinar is part of an ongoing series featuring Synergy's subject matter experts giving you thought leadership insights into issues that impact personal injury recoveries. During today's presentation, if you have questions, type them into the control panel where it says questions. If we don't have time for a live Q&A today, or your question isn't answered, a Synergy subject matter expert will contact you to provide answers to your questions. Before starting today's webinar, the following is a brief presentation giving you an overview of what Synergy does in 30 seconds. A trial lawyer's job isn't to know all the nuances of issues to be addressed when a case is over, to know what it takes to keep Medicaid in place or SSI, preserve Medicare and comply with the Medicare Secondary Payer Act, and resolve complicated liens that may be present when a personal injury matter is resolved. Liens like ERISA, Medicaid liens, Medicare conditional payments, MAO plan liens, FEBA liens, all of those issues are things that the trial lawyer or paralegal really doesn't have the time or relevant expert knowledge to deal with. They need an expert strategic partner that they can rely upon that can handle it without question. And that's exactly what Synergy is. It's why thousands of top personal injury firms turn to and partner with Synergy every single day.
Hello, welcome to Synergy's Medicare Secondary Payer Compliance in a Nutshell Expert Roundtable. We are going to be talking about common Medicare Secondary Payer Compliance issues and the questions that we are frequently presented by attorneys as well as their clients. I'd like to introduce you to our panel of experts. You will be hearing from Attorney Evelyn Pacino. She is our Mass Tort Program Manager. We will also hear from Kevin James, who is an attorney, and he is our Lien Resolution Strategy Coach. My name is Rasa Fumagalli. I'm an attorney, and I am the Director of Medicare Secondary Payer Compliance Services here at Synergy. Our first question is for Evelyn. Evelyn, would you please tell us how a person can become eligible for Medicare?
Thank you, Rasa. A person can qualify for Medicare if they are over 65 and they have worked 40 quarters, or they can draw on a spouse's record, or if they are under 65 and they are disabled and they are receiving Social Security disability benefits, then they will qualify for Medicare after a 2-year waiting period unless they have a condition that qualifies them for coverage faster.
What types of Medicare plans are out there, Evelyn?
So there's original Medicare, also called traditional Medicare, which is parts A and B. Part A covers hospital stays and Part B covers doctor's visits. Part D is for prescription drug coverage. Part C is what's called Medicare Advantage, which basically combines the benefits of Parts A, Part B, and Part D. Also provides some other benefits as well, typically, depending on the company that's offering that coverage. And then there are also Medicare supplement plans, which are also called Medigap plans, and those cover the percentage that Medicare or traditional Medicare would not typically cover.
Kevin, is a Medicare supplemental plan the same as a Medicare Advantage plan? Do they have the same recovery rights, or what should people be thinking about when you have a supplemental plan and an Advantage plan?
Medicare Advantage plans and Medicare supplemental plans are two distinctly different things. The biggest difference between them, Medicare Advantage plans are intended to be a full replacement plan for traditional Medicare, while Medicare supplemental plans will cover, usually Medicare traditional will pay 80% and the member's responsible for 20%. These supplemental plans cover that additional 20%, co-pays, things like that. They are a separate product, so it's possible these will be it's a technically insurance product. They do not have the same rights of recovery, and that's the other big thing. Medicare Advantage plans are obviously governed under the Medicare Secondary Payer Act and all the rights and penalties and things that can come with that. Whereas Medicare supplemental plans are very much, they're subject to state law. So their lien is kind of like any other lien that would normally be subject to whichever state they were in. So the understanding the difference is very important, because I often have clients confuse this issue where they'll refer to an advantage plan as supplemental, or a supplemental plan as an advantage plan, and that affects the recovery rights. It also affects the consequences if for some reason one of these liens is missed. So they are, again, two distinct different things, and they do have distinct rights.
Can an individual change their Medicare plan during the life of a case, or are they stuck with whatever plan they signed up for originally?
The short answer is on this question is these plans, a patient can switch between Medicare Advantage plans or between Advantage plans and traditional Medicare. Particularly if it's a case where a person has treated a lengthy amount of time, it is very possible to have like more than one Medicare Advantage lien on a case. I have had a case where I did have an individual who had 5 different Medicare Advantage liens on his one case, because he had treated so much for so long. The other thing that often happens, and we're actually seeing a lot of this right now in the marketplace, is Medicare Advantage plans are usually offered by county. So they're offered as a certain geographical area, and that's usually by county. Many major insurers are pulling back on where they are offering these Medicare Advantage plans. So it's quite possible that when open enrollment comes around in the fall, that if somebody was like Aetna may have decided to cease offering that Medicare Advantage plan in that county, or where the member resides, and they'll be forced to switch their carrier in that time frame. So one of the ways you can kind of avoid this as far as liens goes is, if you've had a patient that's treated a significant amount of time, that all the relevant dates of their treatment are covered under the liens that you have in the itemizations. They don't just stop at like some point a year from present day, and we don't know, there's no claims, between for a year from this one plan. There's a good chance they had to switch at some point. So yes, it is possible for members to switch also back on traditional Medicare, or from traditional Medicare to Medicare Advantage. So generally, though, with Medicare Advantage and traditional Medicare, they can't be on both at the same time, is really the thing, but they can switch in between the two.
We oftentimes have situations where injured parties don't quite remember what type of plan he or she is enrolled in. How can we sort this out?
Yes, this can be a really complicated issue. But if your client does have Medicare coverage, they should be able to log in through medicare.gov. So if you're able to sit with them when they do that, then you'll be able to see if they're on Medicare, if they've had Medicare Advantage plans, Medicare supplement plans. So everything will show up there. So that can be a really easy and really fast way to verify that coverage. You can also check medical bills and records, because they will often say who paid the bills. This can be really helpful for tracking down Medicare Advantage plans, because it will typically show which company paid those bills. You can also report the case to Medicare. So, if that person does have coverage, then CMS is going to respond saying that they've opened a case. But if there were no conditional payments, then you'll just get a letter back that confirms that. And then when the case resolves, typically they would just close their file. If there are conditional payments, then they're going to respond and let you know what they found as far as claims that might be associated with the case. But if the person doesn't have coverage, then they'll tell you that too. So you'll get a letter back that says that they were not able to identify the person as a Medicare beneficiary. And then lastly, there is some reporting that defense has access to that will tell them if the person has Medicare coverage or if they've had a Medicare Advantage plan in the last 3 years. So unfortunately, that's not something that we have access to or anything that plaintiff attorneys have access to currently. But if you have a good relationship with defense, then you might be able to ask them to share that information with you. So it's kind of a long shot, but it might be worth it if you're not finding anything else.
Now, I'm going to address what you should watch for when You are settling a Medicare beneficiary's personal injury case. When you have a settlement with a Medicare beneficiary and it's a personal injury settlement, there are certain things that you need to consider. You should think about the Medicare Secondary Payer Act. This law basically makes Medicare a payer of last resort whenever you have an accidental injury or some sort of ingestion type of or implantation loss, and you have a Medicare beneficiary that is settling a case, whether it's a workers' compensation case, liability case, or no-fault case. There are basically three things that you need to be mindful of. The first is that if Medicare paid for injury-related treatment before the case settles, these payments were conditional payments, and there's an obligation to address them and reimburse them in connection with the settlement. When I'm referring to Medicare, not only am I including traditional Medicare, which is Part A and Part B, but there's also a need to address Medicare Part C or Advantage Plan payments, as well as payments made by standalone prescription plans under Part D. The second component that you should be thinking about involves the mandatory insurer reporting obligation under Section 111. And this reporting obligation falls on the defense. It is done by their responsible reporting entities, RREs, and it requires the plans to report the date of the settlement agreement, the date of the accident, as well as the diagnosis codes that are being addressed in this settlement. It's a good idea to be aligned with the defense when it comes to these data points so that there aren't any potential mix-ups with Medicare that might impact your client's ongoing eligibility for Medicare benefits. We also recommend that you consider whether your settlement is cost shifting post-settlement injury-related care to Medicare. If you were alleging that your client is going to need a great deal of post-settlement injury-related care because of the accident, you want to make sure that you have a discussion with your client, letting them know of the potential impact of the Medicare Secondary Payer Act on their ongoing eligibility to have Medicare pay for this injury-related treatment. We recommend that this discussion be done with an expert, whether the expert is within your firm or if you reach out to an outside group such as Synergy. It is also very important that you document your file to show the steps that were taken to consider Medicare's interest when it comes to this particular settlement. How would I go about initiating a conditional payment search?
So you can initiate the search for conditional payments by reporting the case to the BCRC, which is the Benefits Coordination and Recovery Center. This is the part of CMS that handles debts of Medicare beneficiaries. And one of the easiest ways to do that is to report the case through Medicare's portal. So you can do that instantly and typically can get a case set up same day. You can also fax information to them, or you can call it in and they will set the case up for you over the phone. Just know that in order to set up a case, you'll need to provide the person's name, date of birth, their social security number or their Medicare ID, their date of injury, and any injury codes associated with the case.
What do I do if the conditional payment letter does not show any payments by Medicare, but I know that my client received quite a bit of treatment?
Yes, so this can be really concerning. So if you are sure that Medicare has paid claims related to the case and nothing is showing up on the conditional payment letter, there's a couple of things to think about. One is how recent were the claims? So it sometimes can take 90 days for Medicare to process claims and then could take some additional time for them to connect them with the case and put them on the conditional payment letter. So there's always a possibility that they just are not processed yet. You also might want to double check to make sure that the information that was provided to CMS was accurate. So if CMS has the wrong date of injury, or if they have the wrong injury codes, something like that might make it hard for them to connect those payments to the conditional payment letter. And then lastly, this can be a really big clue that the client might have other coverage. So particularly if they have a Medicare Advantage plan, they may be thinking about all of that as Medicare. So they may not have been really clear that they actually have a Medicare Advantage plan through Humana or some other company. And so it's a good spot to initiate a conversation with your client or whoever is handling their affairs to figure out if there might have been any other coverage associated with their case.
Can I rely on a conditional payment letter from Medicare before the case is fully settled?
No, you never want to rely on a conditional payment letter or a conditional payment notice, even though they can look kind of final. The conditional payment notices in particular are going to show you what settlement information was reported and will tell you that a demand is in progress. However, they can change. So even if the conditional payment notice has one amount on it, that may change drastically by the time they actually issue the demand. So it's really important to remember that Medicare can always sweep for more claims. They can do this periodically. They can do this if they get additional information or when they are notified of settlement. So you never want to rely on a conditional payment letter or a conditional payment notice.
Is there any way to ballpark what Medicare may be looking to recover before I get a final demand?
Unfortunately, there is no reliable method for ballparking what Medicare may be trying to recover on a case. That's why it's really important to report the case to Medicare early and to monitor it as the case progresses. That way you can keep an eye on it and you'll have as many opportunities as you need to file disputes. If you're not aware of the final conditional payment process, that can be really helpful as you're going into mediation or into settlement talks. So basically this is a way to lock in Medicare's conditional payment amount so that it doesn't change when you go to get the demand. So this is a process that you enroll in on the Medicare portal. You can do it up to 180 days before you're expecting settlement or before mediation. And then, as you're getting ready to have those conversations, you request a final conditional payment letter. And so as long as the case settles within 3 days of getting that letter, then Medicare will honor the amount on the conditional payment letter when they issue the demand. So long as you then also report settlement within 30 days. So it's kind of a lot to remember. You kind of have to thread the needle on this one, but it can be really helpful just so that you can go into those discussions knowing exactly what that conditional payment amount is. And then always remember that Medicare is going to reduce down to whatever the net settlement is. So if you do have a really high conditional payment amount, they're going to reduce, down to the gross settlement, and then they'll do a reduction for fees and costs also. So obviously there's, some additional methods to get it reduced beyond that, but know that they're always going to be limited to the net settlement.
How could I go about disputing conditional payments?
There are a few different ways to submit disputes to Medicare, so you can always fax or mail them in. We really like using the Medicare Secondary Payer recovery portal. It's a really easy way to interface with Medicare and to file disputes. So you can download a list of claims in Excel. That makes them really easy to sort however you need to. It also will translate all of the ICD codes, which, if you're looking at a conditional payment letter, it's just going to include the codes. It won't tell you what they are, but all that information is on the portal. I included a screenshot here showing what you would see in the portal also. So that can be an easy way. If you're just trying to get a sense of what is on the conditional payment letter, you can very quickly go through, and as you roll your mouse over the list of codes, it's going to tell you what they are. And then you can also upload any supporting documentation that you have. So if you're providing medical records or settlement documents or something, it's very easy to upload all of that through the portal.
What could happen if I forget to address the conditional payments and I disperse the settlement funds?
So if you don't report the case to Medicare, then ultimately they're going to find out about it from defense. So defense has a responsibility through their Section 111 reporting to report cases and settlements to Medicare, and they can be fined for not doing so timely. So they're pretty good about getting those reports out. And then once Medicare is aware that a settlement has occurred, they're going to issue their demand. If that demand is not paid within 60 days, then it starts to accrue interest. This accrues monthly at a rate of about 12% currently, although it can fluctuate. And then ultimately they will refer it to the Department of Treasury for enforcement. And so when that happens, Department of Treasury can start taking money out of the person's Social Security check or out of their tax refund. And that can be a really difficult thing for someone who's already living on a very limited income. And then, unfortunately, you may not even find out that any of this is going on. So if you haven't reported your involvement to Medicare, they would have no reason to be sending you correspondence about it. So those letters might be going directly to the client. They might not know what to do with them. They might throw them away. Or if they've passed away, then, those letters could just be going to a home where they no longer live. So you just may have no way of finding out about it. And, most importantly, there is some exposure for attorneys here. So, and under the Medicare Secondary Payer Act, Medicare can pursue double damages against any party that handled the funds. And that does include the law firms. So we have seen some cases where Medicare has gone after plaintiff attorneys on this. Fortunately, those have resulted in very large fines and some really bad press for the firm. So it's really just a difficult situation all around. So you want to do anything that you can to avoid that.
Does Medicare's conditional payment letter include the amount of any Medicare Advantage plan liens?
So any conditional payment letter that you receive from traditional Medicare is not indicative of any claims related to a Medicare Advantage plan. They will not be on the itemization. They will not be part of the balance that CMS is saying that they are due back. Medicare Advantage plans are their own thing. So a lot of times where we've seen clients get in trouble with these is they receive a no paid letter or zero paid claim letter from traditional Medicare, and they assume that there's no Medicare lien. That is not correct, because there could be a Medicare Advantage plan that was the one that was actually paying the claims, and we have seen that where a client has gotten a zero paid letter or a conditional payment of zero balance from Medicare traditional CMS, dispersed funds, and then 6 months later a Medicare Advantage plan asserts a lien because they found the case on their own. So you cannot rely on the CMS ledger or CMS to tell you that there's a Medicare Advantage plan out there somewhere that has paid claims.
How would I go about addressing Medicare Advantage plan liens?
So this is probably a larger question than I'm kind of one of those people that can talk about liens for 2 hours if you let me. So this is pretty a big question, but so I'm going to try to hit the big things. How you attack a Medicare Advantage lien as far as obtaining a reduction goes. Really, the thing you really have to do on these cases, though you should do it with all liens, is audit those claims the subrogation vendors have produced to ensure that they're all related. It's not uncommon for Medicare eligible patients to have a number of different things in their medical history, pre-existing conditions, all of those things that the subrogation vendors, while not always maliciously, will try to attempt to include in their liens. So you really have to pay attention to those itemizations to make sure all the claims are related. I cannot tell you the number of times that I have found diabetes treatment in car accident liens. It's, whether the rep just missed it or whatever, it does occur quite a bit. Other thing with Medicare Advantage liens is most subrogation vendors, but not all, will provide a procurement cost reduction just like CMS does. It's Synergy's position that that's required under the statute, even for Medicare Advantage plans. There are vendors out there that try to argue against that. Most notably, the Rawlings Company will often say because their contract language, they don't have to reduce for the procurement costs. And Synergy vehemently disagrees with that, and we do have to argue against it quite a bit. So you may run into it, particularly with the Rawlings Company, although they're not the only one. They're probably the greatest offender of this. We've not seen them attempt to litigate that either. One of the other ways you can try to get a Medicare Advantage lien reduced is there is some case law out there, particularly about wrongful death and in the Second Circuit that somewhat limit a Medicare Advantage plan's claim over who they can actually pursue to satisfy the lien. So this is often, the hardships stuff is discretionary. So for most Medicare Advantage plans, it's discretion whether they reduce below procurement costs or not. Some are more willing to exercise that discretion than others. There are, like I was saying, there are some specific cases out there under specific case facts that can further affect what would be due back to Medicare or a Medicare Advantage plan. The most notable circuits that have some play is the Second Circuit, the 11th, and the 9th, and as it relates to wrongful death in the 11th and the 9th. So you just kind of have to look into it in your specific case facts whether it would apply or not.
What could happen if I forget to address the Medicare Advantage plan payments in a case?
Okay, so forgetting or ignoring a Medicare Advantage lien or not finding a Medicare Advantage lien, the possible bad things that can happen are unfortunately extensive. It can result in, just like traditional Medicare, double damages. Also, if Medicare or a Medicare Advantage plan is required to sue to enforce their recovery rights, the procurement cost reduction will be taken off the table, and Medicare does not have to reduce its lien for that provision. So basically, it's the same penalty provisions as traditional Medicare. Also, it's important to note the Medicare Secondary Payer Act, as it applies to the Medicare Advantage plans and everything else, they have direct rights basically to anyone who touched money, i.e., they can go after the attorney, the attorney's firm, the third party, the insurance company, whether first or third party, just anyone that was ever a holder of settlement funds can become a target from Medicare. A Medicare Advantage plan. It's also important to note that there's some third or property and casualty insurers out there that think wrongly that if they get an indemnity agreement from you as part of their release, that will protect them from a claim from a Medicare Advantage plan or traditional Medicare. It will not. So it's very important. These things often cause our clients problems when, for one reason or another, a Medicare Advantage plan lien was not resolved, at the time of settlement or around the time of settlement.
Do I have to address payments made by a Medicare Part D drug plan?
Yes, CMS takes the position that the Medicare Secondary Payer Act applies to Part D plans as it applies to Part C plans. What Part D plans were a prescription drug benefit plan that was put into by the second President Bush. Again, not nearly as extensive litigation on these as there has been around Medicare Advantage or Part C plans. But CMS, as a federal agency, takes the position that the MSP applies to Part D plans as it applies to the Part C, which means they have all the rights as traditional Medicare. Obviously, that positioning has been a little bit weakened by the fact that the Supreme Court has overturned the Chevron deference. But CMS still will take the position in any kind of dispute that the Medicare Secondary Payer Act applies to Part D plans.
What is Section 111 mandatory insurer reporting? Section 111 mandatory insurer reporting is the enforcement mechanism or the teeth of the Medicare Secondary Payer Act. It is something that was passed in, I believe it was 2010, and the intent is that Medicare gets notice of every settlement with a Medicare beneficiary. There are different types of reporting obligations that fall upon the defense. So if you have a workers' compensation case, for example, and it is an accepted case and you are representing the injured employee, and the injured employee is a Medicare beneficiary, the defense or the workers' comp insurance carrier is going to report their responsibility for ongoing medical to Medicare under this Section 111 mandatory insure reporting. So Medicare is going to know that the ORM, or ongoing responsibility for medical, falls on the workers' compensation insurance carrier as opposed to any other party. Once they have this information, they are not going to pay for any sort of medical treatment that is tied to the injury that was reported. They are also going to get a report when the case settles or when this ORM terminates. There's also a mandatory insure reporting obligation that applies when there's a liability settlement and a no-fault settlement with a Medicare beneficiary. The current total payment obligation to claimant, or TPOC settlement reporting dollar amount for a physical trauma is $750. That is a pretty low reporting threshold. So when you have a settlement with a Medicare beneficiary and the defense is, talking to you about the data points that they need to report under mandatory insure reporting, they are simply seeking information that they are entitled to. They and you should be on the same page when it comes to the date of the accident, when it comes to the date of the settlement agreement, and it's always a good idea to be on the same page when it comes to the diagnosis codes that are going to be reported. I know my client is going to need injury-related treatment after the case settles. Should I do anything? When you reach a settlement agreement with a Medicare beneficiary who is going to need or likely to need ongoing injury-related medical treatment, as I mentioned earlier, it's always important that you advise them of the potential impact of the Medicare Secondary Payer Act on their settlement. So, because Medicare is a payer of last resort, and this applies to liability, no fault, and workers' comp settlements, if your settlement is funding or contemplating future injury-related medical, it is a good idea to discuss putting aside a portion of the net settlement to avoid cost-shifting future injury-related expenses to Medicare. Another possible option when you have a situation where a person will need ongoing injury-related care is to see whether the settlement actually funds future medical. If the past medical or the objective economic damages are so great and you have a situation where your settlement is limited because of the policy or other liens that are going to have to be paid out, you can determine that this is a situation where the settlement is simply insufficient to fund future medicals and not put any funds aside. There might be other situations or circumstances that might help your client avoid cost shifting these expenses to Medicare. They might have the ability to obtain coverage through a spouse's group health plan, or they might choose to simply pay for post-settlement injury-related care from the settlement. They might also decide after the discussion about the potential impact of the Medicare Secondary Payer Act that they're prepared to assume the potential risk that Medicare might deny post-settlement injury-related care. There really is no one-size-fits-all solution. The course of action that is followed really depends upon everybody's comfort level with risk. Does a liability Medicare set-aside fund the future treatment at the Medicare fee schedule? Liability Medicare set-asides are priced out at the usual and customary charges for the geographical area in which the service is going to be provided. Workers' compensation Medicare set-asides, on the other hand, are priced out at the state workers' compensation medical fee schedule. The reason that liability Medicare set-asides are priced out at usual and customary, as opposed to the Medicare fee schedule, is that an individual cannot force a provider to give them the Medicare fee schedule when they're receiving services. This point is something that does not seem to be taken into account with the new Florida statute that requires, future medical, past medical for 2025 filings to be priced out at 120% of the Medicare fee schedule. There are many providers who, for whatever reason, also opt out of the Medicare program. What if liability Medicare set-aside takes up most of the settlement? Liability settlements are different than workers' compensation settlements. A liability settlement is going to cover many more buckets of damages than a workers' compensation settlement. So in light of this, we do not recommend that a liability settlement fully fund the future injury-related Medicare covered services. Rather, we complete a reduction analysis which apportions the amount of future medical based on an examination of the total potential value of the case. Our process will begin with the preparation of a full future Medicare set-aside number. We then look at the ratio between the total potential case value and the actual net settlement to the injured party after attorney's fees, costs, and liens are deducted. We apply this percentage, this ratio then, to the Medicare set-aside number to come up with the lowest defensible number that we would recommend be set aside from the net settlement as a Medicare set-aside. When you use this reduction analysis formula, you are making sure that there's a reasonable number that is set aside for future medical as opposed to the net settlement being completely used up for future medical. How do you administer a Medicare set-aside? Do you prepay the amount to Medicare? Medicare set-aside funds are not prepaid to Medicare. When you have a Medicare set-aside that's going to be funded from your net settlement, the funds can be administered in two different ways. They can be self-administered, which just requires that the injured party be competent to manage the funds. They would put the funds in a separate interest-bearing account at the bank. They would use the funds to pay for post-settlement injury-related Medicare covered treatment. They would keep track of how they're spending the funds from the account. And when the account is properly exhausted, any additional injury-related bills would go to Medicare. You can also choose to professionally administer the Medicare set-aside account, and that is actually the recommended approach by Medicare when it comes to workers' compensation Medicare set-asides. When you hire a professional administrator, you will enter into a professional administration agreement with them. There's usually a one-time lifetime administration fee. They will manage the funds for you. They will review the post-settlement medical bills to make sure that they're coded properly, that they're related. Professional administration oftentimes extends the life of the Medicare set-aside funds because administrators may be able to get discounts or better deals on durable medical equipment or pharmacy prescriptions because of the relationships that they have with various suppliers. I have seen settlement contracts where the plaintiff is asked to waive the private cause of action. What does this mean? Private cause of action can be found in 42 U.S.C. 1395 YB3A. And the language states that there is established a private cause of action for damages, which shall be in an amount double the amount otherwise provided in the case of a primary plan which fails to provide for primary payment or appropriate reimbursement in accordance with paragraphs 1 and 2A. Now, this provision has been used by beneficiaries. It has been used by Medicare Advantage plans that are seeking reimbursement. When you see this waiver in your settlement documents, it simply means that the defense wants to make sure that you are not going to sue them for double damages in the event that they failed to address conditional payments. As a side note, conditional payment reimbursement is almost always going to be a burden placed on the injured party in the settlement terms. What should I be looking for in the Medicare Secondary Payer Compliance section of a settlement release? Oftentimes we see people send us settlement terms that seem like they've been copied out of a Medicare Secondary Payer Act treatise. And there are so many boilerplate terms where you actually see inconsistencies, such as requiring CMS review of a Medicare set-aside proposal when CMS review is not available. There might also be terms that really don't apply to the specific case that is settling. When you are reviewing settlement documents, these are the keys that you should be looking for. You should be looking to see whether the terms address conditional payment reimbursement, whether it's traditional Medicare payments or Medicare Advantage plan payments. You also want to object to terms or hoops that the opposing party may want you to jump through, which are unnecessary. In the liability space, for example, there should not be a provision that states that you're going to submit a liability Medicare set aside to CMS for review. I mean, that is something that is generally not available. Furthermore, it's unnecessary. Typical language will talk about the party's consideration of Medicare status as a secondary payer. As I mentioned, you are going to see way too many terms in there. I would not object to a waiver of the private cause of action since it's not something that you would generally be pursuing, since the obligation to reimburse those conditional payments in a liability settlement will generally fall on the beneficiary. So watch the settlement terms for conditions that cannot be met. Is there a best way to manage my cases when it comes to avoiding potential issues with Medicare? It's a good idea to have a routine or a certain process that you follow when you are representing Medicare beneficiaries in their personal injury cases. We would generally recommend that you set up a process that would help you identify Medicare beneficiaries either at the time that you sign them up or at the time that you're settling or about to settle the case. You should also consider whether the injured party has applied for Social Security disability benefits, and if awarded, at what point in time they will actually become Medicare beneficiaries. It's very important that you have an individual within the firm or you outsource the conditional payment identification and reimbursement of the claims. There are many ways that you can challenge conditional payments, whether the charges are unrelated, if they're bundled, or whether it would be appropriate to seek a financial hardship argument or a compromise or waiver. We also recommend that when you are reaching a settlement with the defense, that you have a conversation about the mandatory insurer reporting obligations. You want to be aligned with the defense in terms of the date of accident that will be reported, the date of the settlement agreement, as well as the diagnosis codes that will be reported. Sometimes people actually put the diagnosis codes to be reported in the settlement documents themselves. We also recommend that you have a process where every Medicare beneficiary that has a personal injury settlement is advised about the potential impact of the Medicare Secondary Payer Act on the settlement. You can do this internally or you can consult with an outside expert. It's imperative that you have documentation for your records showing that this very important issue was addressed and the way that you considered Medicare's potential interest in the settlement. Do not wait until the very last moment to address these Medicare secondary payer compliance issues. A proactive approach is best. We are at Synergy are here to help you with your Medicare secondary payer compliance needs, and I thank you for your attention to our roundtable.
Hi, this is Jason Lazarus, founder of Synergy. Thank you for attending today's Synergy Insight presentation. Before we conclude, I wanted to take a moment to tell you a little bit about our team pictured on your screen right now. Synergy is a mission-focused organization dedicated to improving the lives of the injured as well as their families, and freeing trial lawyers and their firms to focus on what they do best. We all care about this mission deeply. I am so proud of our incredible team that works tirelessly each day to get the best possible results for you and your clients. It's why Synergy has been consistently recognized as one of the fastest growing companies in the US. Contact us today to find out about forming a strategic partnership with Synergy that will transform the efficiency and profitability of your practice.